Well, hello there, and welcome to the Employment Law Show. We are back for another week. John Scholes here, and Lior Samfiru, of course, employmentlawyer.ca. Anytime, reach out to Lior on your own time. Have a chat, conversation. Really simple, 1-855-821-5900, help@employmentlawyer.ca. And the only website you should be going to, not Reddit, not Google, not your friends. There's only one reliable source. We keep telling you that, pocketemploymentlawyer.ca. We will put that and the severance calculator to the test in just a little bit to show you how it works. And lots of other things coming up on the show today as well. We got phone calls from our radio listeners. We have your emails coming up here as well, and always a main topic, and that is when workplace changes become constructive dismissal. If you're not familiar with that term, we'll break it down in just a bit, and lots more as well, including rapid fire at the end of the show. So it's a busy half hour, so we'll get started. Lior, before main topic and the phone calls and all that stuff, week that was, what do you got cooking this week, pal?
John, it's so good to be here. And you know, every year kind of we do this show, and I don't know, is it going to be stuff that we need to talk about? Are people going to eventually learn all their employment rights? Well, by the virtue of the calls that I get every single day, there's still a lot to talk about. There's still a lot of problems to resolve in the workplace. There's still a lot of employers that are not abiding by their legal obligations to their employees. And that's what we cover on this show. And we're going to continue going until there's no more questions to ask. I don't think that's ever going to happen. If you want to know about your employment law rights, if you want to know about what your boss is doing and whether that's legal or not, this is the time, this is the place. You have so many rights. I've said this before, but it bears repeating. We have some of the best employment laws anywhere in the world right here in Canada. And on this show, we'll explain those to you. We'll explain what you are allowed to do and what your employer cannot do to you if you lost your job, if you've been constructively dismissed, you're not being accommodated, you're being mistreated by your boss. All those things we will cover always so that you have the power of knowledge. This is a 30-minute show. It's going to be very busy. Beyond the 30 minutes, you can reach out by phone and email. We'll give you that contact information if you want to have that private chat. But now that we know what we want to do, I say we do it. Let me tell you about a case that came across my desk just over the past few days. And by the way, this is actually a series of cases, but 3 or 4 that I dealt with, all very similar, and it had to do with small employers letting employees go. In many cases, either they're shutting down or downsizing. And the reason why I want to mention that here is that in every one of those cases, those employers, when they let the person go, said, well, we're a small business. We only have a few employees. We don't have to pay you severance because that doesn't apply to us, doesn't apply to small employers. That severance thing, that's for big employers. And in every one of those cases, I got calls asking me, is this right? As employees, are we out of luck because we were working for small employers? The answer here is simple, it's straightforward, and it's important. No, you're not out of luck. You get the same amount of severance, the same amount, whether you work for a large company or a small company, whether there's 1 employee or 1,000 employees, you are getting severance, you're owed severance. The law does not say that employees that work for small companies don't get severance. That is a very, very common misconception. And in these cases that I talk about the 3 of them that I had this past week, those employees were owed anywhere from 8 to 15 months of severance. So very important. I want everyone to remember this. I want employers to know this as well. Severance has to be paid. If you have an employee that lost their job, the employer must pay severance regardless of the size. So does it apply to you? If you've lost your job, it does. If you lost your job, you call me regardless of what your employer says.
And again, what I always say about severance, I said it off the top, that one stop, right? Pocketemploymentlawyer.ca. We'll put it to the test here momentarily, but we get a lot of phone calls on our radio show. By the way, employmentlawyer.ca. Find a station near you that carries our show. Listen weekly. We've been doing that for about 13 years, I think. Wow. Anyway, call in. Maybe your phone call will appear on a later episode of this show. Want to get to the first call for the day, Lior? Let's listen up and we'll answer it. Here we go.
I work in the private sector as a chef, and I was just let go from my position yesterday without cause after being there for 10 months. And I was given papers that I had 1 week to sign that gave me 2 weeks severance. Otherwise, if I didn't sign, I would forfeit my severance.
How old are you?
59.
They did everything wrong.
Everything wrong. Now, I started off the show a moment ago by talking about misconceptions. Yep. The misconception I talked about is the fact that a lot of people believe that small companies don't have to pay severance. Well, this call touches on another misconception, and that is that if you work for a short period of time, in this case 10 months, you don't get much severance. You get very little. Wrong. False. Even as a short service employee, you get substantial amount of severance. This person worked for 10 months and they were given or offered 2 weeks pay. Many people may say, well, that's okay. 2 weeks pay, you've only been there for 10 months. That's fine. It's not fine. It's not even close. That is a wrongful dismissal because she's owed more. So the last thing I have to do right now is to show you how I can find out, and you can find out, how much severance this person is owed or you're owed. We're going to use the severance calculator. You'll find that at pocketemploymentlawyer.ca. Let's use that right now and let's see what that gives us. So we know that this person was let go after being there for about 10 months. They're 59 years of age. They're a chef. They were offered 2 weeks. The answer is they're owed about 3 months severance. And by the way, that 3 months, that's conservative. That person could have been owed 4 or 5 months even. So that's why we use the severance calculator. Again, pocketemploymentlawyer.ca. And of course, please, it's false to believe that just because you worked for a few months, you don't get severance or you get very little severance. You're going to be surprised by just how much you're owed.
A little bit of panic in that caller's voice. I remember that phone call because of that 1 week, that pay deadline. If you don't sign, you're not getting anything. How about that piece?
So I'm going to offer you really bad severance, 2 weeks instead of 4 months, and I'm going to put a deadline on that. Well, how ridiculous is that? That is a pressure tactic. Unfortunately, John, it's an effective pressure tactic because a lot of employees think that, well, I have no choice but to accept it. There's a deadline, and that seems serious. Wrong. That deadline is nothing. It doesn't mean anything. Your rights don't expire on Friday or whatever the deadline is. You have 2 years to pursue your entitlement. So please, I don't care what the deadline says. You can ignore it. If you lost your job, you have to understand what you're legally owed. That's why you go to pocketemploymentlawyer.ca, or that's why you call me, so you don't accept inadequate severance.
One of the other things I thought was kind of unique about this call, not uncommon, is that this person's a chef. I mean, that industry, it's like whack-a-mole. They're changing jobs all the time. They're darting all over different restaurants. 10 months actually isn't bad for a chef. But I mean, how many? If there's 100 chefs that come to you who have been let go, what, 99 of those have probably been offered no severance because they figured you're a chef, you move. I don't know anything. It's been a month. Same thing, right?
If I received a call from a chef and they were offered proper severance, I would be shocked. I'd have to take the rest of the day off because I think the world is ending, because it's that unlikely. No, it's very likely with chefs, with many other people as well, to be offered inadequate severance. And the law doesn't distinguish between those different roles. If you lost your job, you are owed severance, of course. Chef, really any role, yeah, that severance is going to be a lot more than you realize.
That is phone call number 1. We will get to phone call number 2 as well. Let's hear it.
I have a friend who advised me that her company recently laid her off after 15 and a half years of service. He said the layoff is for 35 weeks, after which severance will be paid. Severance will be paid if she is not recalled. Is she entitled now to the severance, or must she wait 35 weeks?
So this call, yet again, an example of why we do this show, an example of misconceptions that are out there when it comes to employment law. We have to disavow people of these misconceptions. No, when it comes to a temporary layoff, in most cases, that is not something your employer is allowed to do, which means you don't have to wait and see what happens in 8 weeks, 20 weeks, 35 weeks. You can get your full severance now, effective immediately, because your employer is doing something they're not allowed to do. A lot of employers don't know this. They may say, well, we're going to put you on a layoff, and only if down the road we don't call you back, that's when we're going to have to pay you severance. Wrong. False. If you're put on a temporary layoff, and of course we're talking about non-union employees, if you're put on a temporary layoff, you are owed severance now. You don't have to wait. You don't have to sit at home and see what happens. If you want to do that, if you want to just get your pay and move on, call me.
What is that whole math? Demystify that 35 weeks, 26 weeks. That always gets factored in somehow. When does that even apply?
So an employer is allowed to contract for the right to put someone on a temporary layoff. So you're allowed to sign an employment agreement that says the company can put you on a temporary layoff. In those situations, that layoff can last up to 35 weeks. But most people have not signed an employment agreement that said that. Most people, therefore, cannot be put on a temporary layoff, not for 3 weeks, not for 35 weeks, not for any period of time. That's why I said, in most cases, no, your employer can't keep you on a temporary layoff, can't put you on a temporary layoff. You can get your severance now.
The phone calls always come in threes on the show. We'll get to the third one on the other side of the break. And when changes in the workplace become constructive dismissal, that's the main topic. We'll cover that as well. Stick around. Lots more Employment Law Show is on the way.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
Maybe the C-do.
All right, welcome back, Employment Law Show. We're set to go with the next segment of the show. Third phone call coming up momentarily, and then we'll get into our main topic as well. Reach out to Lior and his team anytime. In fact, you're encouraged to do so. Don't go down a misleading road. Make the phone call. Send the email, 1-855-821-5900, help@employmentlawyer.ca. Let's get to that third phone call. Listen up. Here we go.
A few weeks ago, I was working. I've been there at this place for over 2 years. I was on the Joint Health and Safety Committee, and for about a year at our meetings, we've been dealing with a certain issue. Nothing's been done about it. It's actually a law. It's not just a company policy that they're breaking. Brought it up at the meeting. That was on a Wednesday. On Thursday, I'm coming into work. I see one of the managers breaking that rule. I showed HR, and the next day they let me go without cause.
Get fired for doing the right thing.
And the responsible thing and the legal thing, man, employers actually do that. And yes, they do. I've seen it before. So let's break this down. No, it's illegal. You cannot be punished for pointing out a safety issue, for even refusing to work because of that safety issue. In fact, you should be doing that. Your employer should be thanking you for doing that, because what you're trying to do is keep everyone safe. And if your employer punishes you because you point out a safety issue, that's what we call a reprisal. In other words, you're being fired, you're being punished for pursuing your rights, for standing up for your rights, or for making sure that your employer abides by its obligations. That is illegal. Just like you can't be fired because you're demanding your overtime or your vacation pay, or you're telling your employer that you're being harassed and mistreated. You can't be fired in those cases. Same thing in this situation. If you're dealing with a safety issue, you're not sure the work is safe for you or for your colleagues, you can and you must point that out. And if your employer does anything to you in that scenario, that other than, of course, fix the problem, it's illegal. Call me. The law has no patience for that whatsoever.
Let's keep rolling into our main topic. When changes in the workplace become constructive dismissal. Got to start off at the beginning, right? Constructive dismissal. If we haven't caught this on the show before, what is it exactly?
So we know what a regular dismissal is, right? A regular dismissal is a situation you're being called into the office. The employer says, sorry, we're letting you go. Your employer makes that decision. They've dismissed you. That's a regular dismissal. Well, a constructive dismissal is a dismissal that happens not when your employer decides to do that. It happens because your employer does something that they're not allowed to do, and you as the employee choose to consider that as a dismissal, as a termination. So a constructive dismissal happens when your employer does something that's not permissible, and you treat that as a termination, like a pay cut, like a reduction in hours, mistreating you, doing something that is not within the scope of employment. And that gives you, the employee, the right to say, I'm going to get my full severance. I'm not going to accept this. I'm not going to continue working with this lower pay or different job. I'm going to choose, me, the employee, to treat that as a termination, and I'm going to make you, employer, pay me my full severance.
All right, well, you did mention pay cut. Nobody likes a pay cut, right? So we'll start there. I mean, is there a threshold? How big does that pay cut have to be until it becomes, breaches the constructive dismissal territory?
So your employer does have a little bit of leeway to make some changes to terms of employment, but it's fairly small leeway. So it's not every pay cut necessarily that's going to result in a constructive dismissal. For it to be a constructive dismissal, we would have to have something usually north of a 10% pay cut. Certainly once you get to that 15% pay cut, you're absolutely in constructive dismissal territory. So if your pay is $30 an hour and they reduce it to $29, you're not going to be happy. Who would be? But it's probably not a constructive dismissal. But if they reduce it to 25, as an example, well, yeah, absolutely. So there's a little bit of leeway, but once it becomes significant north of 10%, you don't have to accept it. You may be able to consider that a constructive dismissal, because who wants that pay cut? And leave and get your full severance.
You know, on that list, there's also change of duty, demotions. When do they cross the line as well? Same type of thing? A little bit?
A little bit. So there's a little leeway that the employer has. So if you're operating machine A and now they're going to want you to operate machine B, that's probably okay, unless there's a good reason why you can't operate machine B. But generally speaking, when it comes to change of duties, there's two things, one of two things you would look for. Either that the job is now very different. It's not what you signed up for. The job that they gave you, the change of duties, is a completely different job now. That's a constructive dismissal. The other scenario is where the new job, new duties become embarrassing. It's not something that makes you look good internally. It may be bad for your career. You know, maybe it's a demotion. Who's going to want to be working with you if you've been demoted? It says something about you, presumably. That is also a constructive dismissal. So if you're not sure if whether what your employer is doing is legal or illegal, let's talk about it. Don't quit, don't do anything until we've had that conversation so we can assess what you're owed and whether what your employer is doing is legal.
Maybe it's a situation where it's not a demotion, but maybe they're picking up your job and moving it across town. I mean, can they do that? Is there a threshold as far as that relocation is concerned?
So a relocation is very, very common, where employers say, well, we're going to move location. And in many cases, that's not allowed. That could be a constructive dismissal. So it's not about the number of kilometers. So it's not about how far the new location is. It's about how this impacts you. Because the company could be moving extremely far, but maybe it now ends up being across the street from your house. Well, then that's certainly not going to be a constructive dismissal. So it really comes down to how does that impact you. If by moving it increases your commute by, let's say, an hour or more, yeah, you're absolutely in constructive dismissal territory. Now, all of a sudden, your commute is very different than it was. It's a change, a significant one, to terms of employment. So if your employer is going to relocate to the point that now you're commuting an extra hour, you may not have to accept that. You may be able to treat that as a constructive dismissal and get your full severance. So you know what to do. Call me.
So if you and I, for instance, were neighbors, work at the same place, they move the workplace, it's another 15 minutes for you by car, but for me it's 3 more buses, same distance. It affects me differently, right?
Absolutely. And I've spoken with people with exactly that scenario over the years. They didn't drive, they didn't have a car, but they liked their work because they could get there very quickly, either walking or public transportation. All of a sudden, they're relocated. Now it becomes a massive ordeal. Several different means of transportation to get there, or a very long period of time to get there. Constructive dismissal. So it's not about how it impacts your friend, your neighbor, your colleague. It's about how it impacts you.
Questions and emails, lots more of those to go in the show as we get into another break here. A short one. We're coming right back with lots more of the employment law. You'll stay with us.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back, and thank you for sticking around the Employment Law Show. We appreciate you stopping by every week. To reach out to Lior anytime, make the phone call, send the email as well. 1-855-821-5900, help@employmentlawyer.ca. And we've already put it to the test once, but it's free and anonymous for you, and that would be pocketemploymentlawyer.ca. Great website. It's really the one-stop shop for everything you need to know for workplace rights and employment law, and you'll also have the severance calculator baked into it. That, by the way, has been used by over 2 million Canadians to realize how much severance they should actually be owed. Again, pocketemploymentlawyer.ca. But we are going to go to terminationquestions.com, another website, free and anonymous. Ask your questions there. They might appear on a future show. For this week, Lior, here we go from terminationquestions.com. Says, my mom has been working for a company in a clerical position for 18 years. She received a letter that the business is shutting down her location in about 3 months. One of her colleagues was recently offered a week pay per year employed. Would my mom be entitled to more? Her salary is around $50K.
So the first thing I want to point out here is that when you get advance notice of the termination of your employment, that amount of time that you got notice counts towards your severance. So in this case, she got about 3 months, so that's 12, 13 weeks of notice. So those 3 months counts towards severance. If she had gotten a year's notice, that year would have counted. Now, in addition to that, she suspects that her mother is also going to be offered an additional week per year, so that would be 18 weeks. So that notice, 3 months plus 18 weeks, roughly 30 weeks. So really the question is, after all those years of employment, is 18 years of employment, is 30 weeks going to be enough? Not even close. And this is a very common scenario. Employers undervaluing and underpaying severance. Not even close. So we need to go back to the severance calculator. That is a tool that you can use yourself to find out how much you're owed, whether you've lost your job, whether you're worried about losing your job, or you're just curious. You find out how much your friend, your neighbor, your partner is owed in severance. It's pocketemploymentlawyer.ca. I'm going to use that for that question, and let's see what is the proper amount of severance in this case. So we know that this person is in a clerical role, been there for 18 years, was offered 30 weeks, a combination of notice and severance. The right amount is 18 months. 18 months. So that's 2.5 times, almost 3 times what she's probably going to be offered. That's why we go to the severance calculator. There's a very high likelihood that if you've lost your job, whether you worked for 18 years like this person or 18 months or any other period of time, frankly, that whatever the company's telling you you're owed is not even close to the right amount. That's why I use the severance calculator, or call me so that you get what you're owed.
When it comes to that advance notice, Lior, is there a stipulation? Does it have to be done a certain way, or can they just kind of lean in and say, yeah, in about 3 months, you're going to be out of here? That'd be great. I mean, does it have to be written? Do they can just verbalize it? How is that legal?
Very good question. So 2 things have to happen for that notice to count towards severance. Yep. Number 1, as John said, it has to be in writing. If it's not in writing, it doesn't exist. So that notice has to be in writing. The second thing is it has to have a specific end date. So, for example, if it only says, well, we're looking to shut down, and at some point in the next 6 months, you're going to be out of a job, it doesn't count. It doesn't count as notice because you don't know, what does that mean? Is it going to be 3 months, 5 months, 6 months, 7? So it doesn't have a specific end date. What it would have to say is, on this specific date, on June 21st, you will be out of a job. So if it's in writing and it has a specific end date, that notice does count towards your entitlements. If it's not in writing, or if it doesn't have a specific end date, it does not count. And that means you're owed even more severance once your employment comes to an end.
It's interesting because one of her colleagues here went through a similar thing. So in the scenario, maybe it's a clerical position. Say there was 3, 4, 5 people at once. Did they all get the same thing? Is it cookie cutter, or it's more, bespoke than that for each person, right?
Like your fine suit, John,
yeah,
it's bespoke. Yeah. And what I mean by that is it's not a standard, well, you get a week per year or 2 weeks, so we can calculate everyone the same way. It's based on your individual circumstances, your age, your position, the length of your employment, and how long it's going to take you to find another job. So your colleague may be a lot more, may be a lot less. So it doesn't really matter what your colleague, your friend is offered or what they're owed. Your individual situation is different, and the law looks at it individually. That's why you go to pocketemploymentlawyer.ca so that you can analyze your entitlements. And no, it's not a week per year. It's not 2 weeks per year. It's a lot more.
Our next question comes from the live stream, which Lior and his colleagues at the firm post on LinkedIn, Facebook, YouTube. You want to join in at ST Lawyers to do so. Here it is, Lior. I've worked for a little over 3 months now. Once my 3 months came up, I was told they are extending my probation. I was promised an increase in my hourly pay after completing my probation as well. Can they do this?
So, yes and no, and here's what I mean by that. Generally speaking, to extend your probation is meaningless. It doesn't do anything. It doesn't give the company new rights, and it doesn't take away rights that you would otherwise have as an employee. So if you're in a 3-month probation and now it's going to be extended to 4, 5, or 6, it's just words. It doesn't mean anything. That means that if you do lose your job in month 4, 5, or 6, you're going to be owed severance as if you were not on probation. So it doesn't matter. Now, in terms of the pay raise, this person was told, after probation, we're going to give you a pay raise. Pay raises generally are within the purview, with the discretion of the employer. So they can decide to who to give a pay raise and when to give that pay raise. So they may say, we're only going to give you a pay raise in these circumstances. That may not be nice or even fair, but legally they can do that. So not much you can do about whether the company gives you a pay raise or when they choose to do it. But if your probation gets extended, no one likes that, and people get very upset and nervous about it. I'm here to tell you, don't stress out. It doesn't matter. The same thing, by the way, applies if you've already been working there and now they decide to put you on probation. It doesn't do anything. It doesn't change your entitlements. It doesn't give you a different legal status. So don't worry about this probation. Remember the general rule. In most cases, probation can only be the first 3 months of employment, and only if you sign an employment agreement that specifically says you're on probation.
So, and everybody, I mean, I used to anyway before we started the show years ago, I assumed that new job, probation, new job, probation. It's always that way. You said it literally has to be written in your agreement, yeah?
It's not automatic. Just because you started a new job, you're on day 1 or whatever it is, you're not on probation. It's not automatic. It doesn't exist just there by operation of law. It only exists if you sign an employment agreement that gives the company the right to put you on probation, only if you sign an agreement. And many employees, even though they started a new job, have not signed anything that says they're on probation, which means from a legal standpoint, they're the same as every other employee. They're not on probation.
If they came for you, you didn't go to them, they came to you and pulled you from already gainful employment, should you sign a probation period for that?
That would be mad, okay, to do that. If you're leaving a secure job, not because you wanted to, because another company came and convinced you to leave, they made you these promises about how successful you're going to be and how much money you're going to make, now they're putting you on probation. Nonsense, of course not. So don't ever sign an employment agreement that puts you on probation if you've been recruited away or induced to leave another job. If they want you, they decided that you're that important that they should take you from another job. No, probation is not appropriate. Also, watch out for any language that limits your future severance. You could be owed enhanced severance, of course, if you're let go by the new company. So you don't want to sign anything in your agreement that limits that.
Let's wrap up this week again with Employment Rights Rapid Fire. Let's get into it right now. Number 1, Lior, can my employer refuse to give me a raise? It's not nice.
So they can, not nice. I agree completely. But generally, that's within the discretion of the company, so they don't have to give you a raise. But if they don't for illegitimate reasons, because of racial reasons or disability or medical condition, that could be a human rights violation.
Rapid fire number 2, can my employer let me go to do a medical accommodation?
Absolutely not. If you need to be accommodated, you cannot be let go. They must accommodate you. They cannot punish you, let you go, or say it's too tough. Again, the Human Rights Code prevents that.
Can my employer deny me a promotion?
They can deny you a promotion as long as they're not doing that for improper reasons. You can't be denied a promotion because of your age, your ethnicity, your marital status. That's a human rights violation. But maybe your employer wants to give it to their cousin. Not nice, but they could do that.
Can my employer suggest I retire?
No. Your employer cannot suggest you retire. They cannot make you retire. And even the suggestion that you should could be a human rights violation. No mandatory retirement. You can work as long as you want.
And finally, quickly, can my employer let me go for cause due to an honest mistake?
Generally, no. It's very difficult to terminate for cause. You would have had to do something terrible, almost on purpose. In most cases, making a mistake, it's not that.
We're done, and you can contact Lior, 1-855-821-5900, help@employmentlawyer.ca, and that website, pocketemploymentlawyer.ca as well. We'll catch you next time right here on the Employment Law Show. Thanks for watching.